start now. Okay, welcome everybody to this Partners in Care Mental Capacity webinar. Today we're going to be delivering the Partners in Care webinar 7, which is Mental Capacity, Sex and Relationships. And I'm very pleased to welcome Lorraine Currie, who's an independent mental capacity consultant. And Lorraine is going to talk about this challenging subject area. So Lorraine, thank you very much. I'm going to hand over to you.
Thanks, Karen. Okay, so let's make a start. Mental capacity, sex and relationships. And I think the first slide probably sums it up. It's a minefield out there. It is a minefield out there. And I may raise more questions than I give answers, but I'm just going to try and take us through some of the situations that challenge in terms of the delivery or direct delivery of care and across this minefield to some extent. At the end, we will have opportunities for questions. So that's the place really to look at examples you might have or things that have not been clear while we've been going along. Okay, so the first thing that I was going to put in front of you really is a kind of quiz. But technology isn't my friend today, and it may not be easy to answer this as a quiz. But what I'm going to ask you to do is perhaps just put a thumbs up. So if you know where to find the reactions, which should be, as Karen always says, you wiggle your mouse and then a list of things comes up. And one of them should be reactions where you can put a thumbs up. It may or may not work. Don't worry too much about it. But there are some questions here that I just wonder what we think the answer is. So the first one is that an assessment of capacity for sex is person specific. So I'm not going to get into yes or no. Who thinks that that is true? If you think it's true, if you can just put a thumbs up, and maybe we'll see how many people do, how many people don't. Okay, we've got quite a few people putting their thumbs up there. Okay, I don't know if that's moved to putting you on the screen. I do hope not. If the next question then is that in doing an assessment of capacity, you have to consider the impact of looking after a baby, stroke child that might be born as a result of sexual activity. So who would, again, put a thumbs up and agree with that one? Okay, I'm getting the views of some of you, not quite as many. The assessment of capacity must involve an understanding that the other person must consent. Some yeses, some nodding. Yeah, I can see from where I am. This is very untechnological, isn't it? But I'm getting some nods and some thumbs and some smiles. Capacity to consent to sex within marriage cannot be assessed under the MCA. Who would agree with that? Again, I'm getting some nods. In a long-term relationship, as long as one person still has capacity, it's okay to continue to have sex. Well, this is fascinating because now I'm getting some puzzled faces. I can only see one or two people, but it's still fascinating. Okay, moving on. Care workers paying for a sex worker on behalf of a person they support is illegal. I'm getting some nods there. And then finally, the relevant information for capacity to have sex is set in stone and doesn't change. Oh, thank you. I'm getting some shaking of heads. Okay, I'm going to address those as we go along. If it was a bit of paper and you were putting a tick on it, it'd be much easier to do it in the old days. So we started at 10 past. Sorry, I'm just going to try and keep my eye on time because it is quite important. So it's a really, really kind of black and white issue, the question of sex and mental capacity, because consent cannot be given without mental capacity. So sex without consent is rape. And this is such a stark delineation that we've got to try and handle this whole situation in a way that respects rights, autonomy, and protection. It is such a stark dividing line by which you could be cast into a situation of enforced celibacy, really, because it all hinges on capacity, mental capacity to consent. Without consent, we know that sex is rape. So I'm going to give you a few little cases as we go along that you can have a look at. And afterwards, obviously, I've just taken snippets here for the slides, but it's worth reading these when you get time and reading the full story. So this was an application by to court due to safeguarding concerns after this lady who had frontal lobe dementia, an intimate relationship with a man she met in the care home. She'd moved from a bungalow into the care home after finding it increasingly difficult at home. Shortly after this, struck up a relationship with a man who had also moved to the care home following a stroke. He is a wheelchair user, but he doesn't have a cognitive impairment. They were seen kissing, holding hands, and several times discovered lying down together in bed. She said she wants to marry him, to leave the care home and live with him in the community. The issue is that if she lacks capacity to consent to sex, then any sexual involvement she has with him is legally assault or rape. So in this situation, which may be familiar to some of you, and I look forward to the bit where we've turned off the recording really, and we can discuss some of your cases. In this situation, the police visited him and explained this to him, because actually she is the one who, if you like, is, dare I say this, is kind of making the advances to him. But he needs awareness of what would happen and what the implications for him are of the fact that she may or may not have capacity for sex. So what would you do was the question there. I'm not going to ask you to answer it now, but I am going to ask you to answer it and discuss it with me at the end. In this case, they were supervised by staff in the care home because of the risk to him of prosecution. And they actually commissioned a new mental capacity assessment, which was detailed, clear, properly evidenced. These are the judge's words, that's why they're in speech marks. A first-class report, a very impressive and careful document. And because of that new capacity assessment, they found she had capacity for sex and contact, but not for marriage. So these restrictions that were in place to monitor and supervise them would now be reconsidered, and the safeguarding plan would be withdrawn, and the care home would follow CQC guidance on relationships and sexuality. So the whole flavour of everything changes because we get a good mental capacity assessment. And 39 Essex Chambers, who I often quote, said that this case illustrates the importance of getting sexual and contact capacity assessments right, particularly when somebody's already confined to an institutional setting where sometimes intimacy is the only thing left. There's a fine line between consensual intimacy, a safeguarding alert, and capacity actually is the thing that draws the line between those two things. Another interesting case that fascinates me, I was talking about this yesterday in a different context with somebody, is CH and a Metropolitan Council. And this was a 38-year-old man. He was married. He had Down syndrome, as did his wife. They'd been married since 2010. They lived in the parents' home of they lived in his parents' home, and they enjoyed normal conjugal relations. So, you know, we all know what that means, but that's the way the court described it. in 2014, the couple sought fertility treatment because they wanted a baby and it wasn't happening. And as an outcome of seeking fertility treatment, he was assessed by a consultant psychologist who concluded that he lacked capacity to consent to sexual relationships. Now, you might want to pause and think about that for a minute on the basis that they'd been having normal conjugal relationships for quite some time. And yet, actually, when his capacity was assessed, he was found not to have capacity. So his wife then was informed in this very formal way. She was sent a letter that said she had to stop having sexual intercourse with him or she would be committing a serious criminal offence, which, you know, is true, but it must have been very, very scary for her. She moved into another room so as not to be tempted. He must have then thought, what on earth's going on? What have I done wrong? And in the courtroom, the judge said it may be a unique case since it looked at capacity to consent to sex within marriage. Other cases where there'd been a declaration about capacity to consent to sex was usually about preventing abuse or the likelihood of abuse. What happened also in this case then was that the court ordered a period of psychological input so that he would have sex education and regain capacity for sex. The problem was that the council in question delayed until between a year and 18 months before providing that, and so he was entitled to compensation. You can imagine this was quite a distressing situation in their relationship. Came about because of that assessment of capacity to consent to sex. So it's about us finding this right balance between empowerment and protection, rights versus risks, which is, you know, an eternal tension. And although it's no different in a sexual context, it is actually kind of quite stark, really. So this case called JB in the Supreme Court, capacity to consent to sex meant looking at these things. In order to have capacity, the person would need to understand the mechanics of the act, the fact that they could say yes or no, and the consequences of sexual intercourse, pregnancy, sexually transmitted infection. So it was quite a low bar, really, in order to have sex. But you will perhaps notice there that it didn't have anything about whether the other person needed to have capacity to consent and whether you needed to consider that. So up until this case in the Supreme Court, the consent of the other person was not part of your capacity assessment. And then JB went through the courts, Court of Appeal, and ultimately to the Supreme Court. So this person, JB, lived in supported living. There were various limitations on his independence, particularly in relation to his interactions with women. It was clear that he wanted a partner and he wanted a sexual relationship. The experts identified that he understood the mechanism of sex, but not the importance of the intentions of others, nor the concept of the need for a partner to consent. So it became a question of, well, is that just a criminal act if you have sex with somebody who isn't consenting? Or is that part of your mental capacity assessment? Again, what would you do? I'll ask you the answers to all these what would you do's in a minute. So at the first hearing, the judge said that the purpose of the MCA is to enable people to have the fullest possible experience of life. And that if we required this chap to understand also that the other person must consent, it would be setting the bar too high and it would deprive him of a fundamental human right. He said it would also place a burden on him that was not placed on others in society. Question mark, question mark. As such, the court at this first hearing held that the test capacity for sexual relationships remained unchanged and that needing to understand consent of the other partner was not part of the test. But it was overturned on appeal, and they started to look at the test for sexual relations in a slightly different way. Rather than capacity to consent to, we should be asking whether the person has capacity to engage in sexual relations. And therefore, that required an assessment about whether there was ongoing consent from the partner. The Court of Appeal held that the proper approach to capacity required balancing three principles: autonomy, which is right at the centre of the MCA, the protection of vulnerable people, and in a wider context, whilst the court mainly aimed at the interests of the person, the court was clear that the Mental Capacity Act and the Court of Protection are part of a wider system of law and justice. And within this system, sexual relations can only take place with the full and ongoing consent of both parties. So nobody could settle it, and it went to the Supreme Court. It was a fascinating hearing. I think I logged in for the first day. After this was heard in the Supreme Court, we got clarity. And this is now the test to work out whether somebody has capacity for sexual relations. Can they understand the mechanics of the act? Can they understand that they have to consent, that they can say yes or no? Do they understand the consequences of sexual intercourse, pregnancy, sexually transmitted infections? And do they understand that the other person must have capacity to consent and must consent throughout? So that really kind of moved it up a notch, really. So they have to understand something about whether the other person has themselves got capacity to consent and whether they do consent throughout. They framed it again as engaging in sexual relations, because that they said that embraces both their capacity to consent to relations initiated by the other party and this understanding of the other party being able to consent and also consenting throughout. So they said that this is now how this assessment should now be carried out. Okay, so I'm going to leave that there. That gave us a new addition. So the test for capacity to consent to sex isn't fixed in stone, because the Supreme Court have looked at it and they have added this additional component about the other person, which actually meant in many cases we needed to revisit assessments of capacity to consent to sex because they weren't carried out with a view to looking at the other person. What if there isn't another person? Because it's a kind of forward-looking assessment of capacity to engage in sexual relationships. Another controversial case that occurred at a very similar sort of time was the question of whether care staff could support this man who had capacity to engage in sexual relationships and to decide to have contact with a sex worker, but he didn't have capacity to make decisions about his care and treatment or manage his property and affairs. So it was the financial transaction that he needed support with. So he told his Care Act advocate and litigation friend that though he wanted to have a girlfriend, he thought his prospects of finding one were limited. He wanted to be able to have sex, and he wanted to know if he'd have contact with a sex worker. You can imagine being asked this question. The advocate raised the matter with his social worker, and in due course, proceedings were commenced. What would you do? And I hope we have some interesting conversations at the end about whether you've been in any similar situations. So it was for the court to consider whether a care plan could be drawn up to facilitate his contact with a sex worker without committing an offence under the Sexual Offences Act. If not, whether it could be read compatibly then with the Human Rights Act, or whether the court should declare it incompatible. And if a care plan facilitating this contact was lawful, would it be in his best interests? The issue, I mean, I personally don't agree with the conclusion that the Supreme Court came to, but who am I? I would have liked it to have gone the other way, in a way, although it raised a lot of controversy because it raised the whole question of sex workers, women's rights, exploitation, and a whole lot of other things, which I'm not taking us into. I'm just looking at the position of care staff paying, facilitating payment to a sex worker. The problem is the Sexual Offences Act, the challenge, in that it says that a person commits an offence if they intentionally cause or incite another person to engage in a sexual activity, and that person has a mental disorder and the person knows that. But it really stems around the use of what does causes or incites mean. If you, as a care worker, support somebody to hand over money to a sex worker, are you causing or inciting them to engage in sexual activity? I would have said no. I would have said you're facilitating it, but the court didn't agree with that. Reasoning being that the Sexual Offences Act is about protecting those people in relationships predicated on trust where there are vulnerabilities. So the Act brings a range of professionals into the realm of criminal law if they abuse power. You can see, you're all familiar with this, you know what this Act is about. It's promoting free and independent decision taking by adults with mental disabilities whilst protecting them from harm where there is this imbalance of power. And Section 39 criminalises care workers who are found to be causing or inciting criminal activity. But here, the wish to engage in sex, is articulated by the man himself. And Section 39 is structured to prevent vulnerable adults from others, protect vulnerable adults from others, not from themselves. This was the reasoning. However, Hayden, who heard this first, the judge, found that what the man was seeking was not in principle going to lead a care worker to be committing a criminal offence. We were all kind of, yeah, okay, this is interesting, where's this going? But on appeal, the court disagreed. They said that he'd been wrong in trying to give a definition of causes or incites. I'm going to read this, even though it's kind of a bit convoluted language. They said the word causes or incites carries their ordinary meaning, and the litmus test for causation is identified in the authorities, so it means previous court cases. Do the acts in question create the circumstances in which something might happen, or do they cause it in a legal sense? So in a way, then, he's saying, if you support him to hand over the money, you are causing that sexual act to occur because you are creating the circumstances in which it happens. Applying the approach previously taken by the Supreme Court in another case referred to there as Hughes, the care workers would clearly be at risk of committing a sexual offence, contrary to Section 39 of the Act. By contrast, care workers who have arranged contact between a mentally disordered person and their spouse or partner, aware that sexual activity may take place, more naturally creating the circumstances for that activity rather than causing it in a legal sense. make your own view. So if you support somebody with their finances so that they can access a sex worker, you are causing that sexual act to occur. Whereas if you arrange for a person and their partner to meet up in circumstances where sex might occur, that's something different, apparently. I'm not going to read this out, but I'll leave it there for you, because what it started to do is create some different boundaries between the Mental Capacity Act and criminal law. They're very, very messy. So the MCA and criminal law around sex is very complex, and it's something that needed to be resolved, but it wasn't really resolved by this case. But the conclusion was, where money changes hands, then the man and potentially his carers would be at risk of prosecution for the strict liability offence of paying for the services of a prostitute who had been exploited. So it's an ever-evolving area. These cases are not the most recent. They're perhaps the most challenging, because they've reached the Supreme Court, which is the last chance to have clarity. So we have got clarity about the test for capacity for sex. We have got clarity about not supporting somebody to pay for sex, but there are lots of other areas. I'll talk about one that's not out yet, but it's an up and coming case, but I'll talk about it when we stop the recording. Often these issues around mental capacity and sex are not just sex alone. So there are a number of cases that I could have highlighted, and I can send you links to them. I may have put some in the newsletter, where the person's found to have capacity for sex but not contact. Now, just leave a couple of seconds while you think about that. It's ever going to happen. If they haven't got capacity to make their own decision about who they have contact with, how, in reality, are they ever going to have sex? You cannot have one without the other. I don't think I'm being dim here, but you cannot have sexual intercourse without having contact with another person. Sometimes it's about capacity for sex, but not finances, as we with that man. He had capacity for sex, but not finances. Sometimes you can have capacity for sex, but not internet use. So that limits some kinds of sexual activity, and also the making of online relationships. You can have capacity for sex, but not care and support. Sometimes it's around poor or no sex education, particularly young people with a learning disability who haven't been given sex education at the time of their non-disabled peers. Sometimes it's about limited opportunities to meet other people. I feel so sorry for the man in the case where he was proposing paying for sex, because he actually faced the reality that he was unlikely to ever meet anyone. And that is a very sad comment on society, disabled people, and sex in general. Sometimes it's not sex alone, but it's the limited awareness of the risks and the dangers posed by other people. Sometimes it's about not having that awareness of risk, because that education and information hasn't been given to the person. And the same, and particularly so, with internet use. There are some wider questions here raised by these various cases. DE, which I'll talk about in a minute, was a person who was quite independent, had a girlfriend, but no capacity for sex. Was that because he just hadn't had adequate sex education, or had been kind of infantilized? There is, in some areas, a tendency to infantilize those people with learning disabilities and not engage with the fact that they want to be enjoying sexual activity on an equal footing with their non-disabled peers. In the case that I have talked about of A, G and C, the woman had dementia, but there were some value judgments there. She was the one who was initiating sex. She was the one who was after the man, if you like. Was she being given an equal opportunity for sex and intimacy? CH, that I've just mentioned, both these two people were married, in a relationship, having sex, and yet the state intervened to determine a lack of mental capacity despite them enjoying conjugal relations. It blows my mind to some extent. And then this one at the bottom, man with autism, who wants a sexual relationship but knows that he will never meet anyone. You know, I just find that incredibly sad that we say those things. And a lot of it is kind of stems from this happy ever after, this, you know, the knight in shining armor, some of the images that we promote and still promote to people who may have some cognitive impairment. So this case, well, this is a blog about a case, and it's about trying to untangle the untangleable, really. Can we have a declaration that somebody has capacity for sex and consent, but not contact? And actually, is restricting contact better than declaring sex completely off the menu? Because once you are found to lack mental capacity for sex, it's off the menu. So are we better looking at contact and who and how the person has contact and who with, and how that can be managed and supported? So I put that there. I recommend to you to read the blog, because we didn't have time really in our time to go fully into that. Another case, DE, that I've just mentioned in passing, was a fascinating case about autonomy. This case was the first permitted authorization for sterilisation for non-therapeutic purposes of a man, and it's 2013. I'm just going to say these things and you make of it what you will. The history is littered with sterilisation of women. But it was 2013 before we had the first non-therapeutic decision that was agreed to vasectomy for a man. And this chap was 37, had a learning disability. He was quite an independent man. He had a lot of freedom and autonomy, and he had a long-standing and loving relationship with a woman. He'd been assessed as lacking capacity to consent to sex and contraception. Some of these things are kind of what we would say in old as putting the cart before the horse. So I don't know if you say that in Shropshire, but his partner became pregnant, subsequently had a baby, and he found that very distressing. But at that point, it's clear that they are having a sexual relationship, and perhaps more input around contraception and sexual relationships might have been wise. So what happened, the point that everybody thought, ooh, the girlfriend's pregnant, what are we going to do? And had a little kind of freak out. His autonomy was really, really restricted. There was a safeguarding there was safeguarding involvement, and he had a one-to-one supporting him, whereas up until that point, he'd been able to come and go as he liked. So there was an interim declaration that he didn't have capacity to consent to sex, and that really resulted in this kind of total life change for him of being supervised, losing autonomy, not being able to do the things that he had done. He couldn't also, because of the nature of his learning disability, when he stopped doing things, he started to lose those skills. So it actually took him quite a long time to rebuild them and to regain his confidence. The fact that he gave in, acquiesced to the restrictions, doesn't mean that it wasn't quite profound. So his quality of life was incomparably better when he could just go and have a coffee in town or go to the local gym with his friend than it was when he was supported by somebody, supervised by somebody to do those things. So actually what happened again was supported decision making should come at the beginning, not at the end. But by supported decision making and a program of sex education, he regained capacity, or regained it for the first time, for sexual relationships. Therefore, things went back to how they were in terms of his freedom and his independence. So a lot, like the other case earlier, a lot hinges around putting in the right support at the right time. There's some extra reading here for you around the United Nations Convention on the Rights of Persons with Disability, because this is a much more sort of, I don't know, forward thinking really around the right for full autonomy, including the freedom to make your own choices, equality between women, and the rights of people with disabilities. So it's a very good thing to look at. And if you look at this thing here, this is an organisation. What are they called now? Anyway, they were previously the Family Planning Association, believes that society puts barriers in place that prevent people with disabilities from being able to express their sexuality. All people with disabilities have the right to enjoy positive relationships and good sexual health and well-being throughout their lives. And we would support that view, I hope, wouldn't we? But it does depend. Sorry, I'm going to go back to that slide. I'm going to go back to that slide. It does depend very much on putting in the right support at the right time. And what we usually see is something goes wrong. And then somebody is found not to have capacity for sex. And then the education is put in place that will get them to the point where we can assess again and say, yes, okay, now they've got capacity for sex. But how much better to make sure that all our young people with a learning disability are coming through special schools and colleges have the same sex education that their non-disabled peers have, and are encouraged to believe and take on board that they have the same rights as their non-disabled peers. Actually, on the other side of that, to look at the fact that it's not just about sexual relationships, and promote this book because I've co-written a chapter in it. Yeah, I don't know where you buy it or anything. I've just found this from somewhere. It's coming out in September. It's Mental Capacity Law, Sexual Relationships and Intimacy. It's an edited collection. So it's written by a bunch of people. So I got to co-write a chapter with Neil Allen. So he's writing from a legal perspective and I'm writing from a practice perspective about ways of supporting people operating within the law, the criminal law, the Mental Capacity Act, but being able to practice supported decision making. So there's a lot in there also. Well, it will be a fantastic book when I see it all brought together. There's also a lot about intimacy. You know, it's not about throwing out, if you like, the baby with the bathwater. It's about how can people find the closeness, the support, the intimacy with another person that maybe stops this side of sexual intercourse, but is still giving them what they long for, that comfort, that closeness, all of those things that we all experienced. Okay, so actually I've finished early. This is the last slide. So I, as Karen said at the beginning, I don't know if we usually record this bit, but we're recording it now. We have these other webinars planned, and I've got some ideas maybe for one of them, which I'll talk to you about when we stop recording. But we're going to stop recording in a second. hand over to you to ask questions.
Thanks, Lorraine. So just before we stop the recording, I did want to say on behalf of Partners in Care, thank you very much, Lorraine. That was a quick romp through. I don't know if that's the right phrase really for that, but a quick romp through this really complex area. And if anyone is interested in the book that Lorraine just mentioned, Mental Capacity Law, Sexual Relationships and Intimacy, it is available on Bristol University Press. You can pre-order it if you want.
Ooh.
If you sign up to Bristol University Press, you also get 25% discount. So if you're looking for some CPD resources, there you go. So I'm going to stop the recording. Thanks, everyone.